Finally, and whereas the Act states, the Parliament of the Republic of South Africa recognizes that housing as an adequate shelter fulfills a basic human need. Housing is both a product and a process. Housing is a product of human endeavor and enterprise. Housing is a vital part of an integrated development planning, and housing is a key sector of the national economy. Housing is also vital to the socio-economic well-being of the nation. And finally, just very briefly, mention to the Housing Development Agency Act as well as the Social Housing Act. Ultimately, what the HRC submits is that the City of Johannesburg has comprehensive social housing policy plans. They have programs which set out exactly how it is that they can implement their social housing programs, and they have merely failed to do so without justification, without reason, and without without taking this Commission of Inquiry into its confidence and explaining just how it is, what steps they have taken to implement this policy and how those steps have just failed. And so in regard to the comprehensive policies above, we accept the following: that the city, together with the province, national and provincial government, the city, the province and national governments are obligated to process the realization of fundamental rights in the Bill of Rights, and in respect of the inner city have simply failed to do so. Second, the city has shown a lackadaisical approach towards its constitutional obligations, failed to plan for and maintain its temporary emergency accommodation, and has in effect become a slumlord. This despite the directives from the Constitutional Court in Olivier Road and Blue Moonlight. We then submit that these are the suggested appropriate steps to be taken if regard is had to the above submissions that I've just made. Firstly, we suggest that critical engagement is necessary between the various state role players, particularly between the local, province, and national government on its national housing policy. Second, the engagement between the city and SAC resolution in the inner city. And finally, the engagement between the various state role players and organizations in policy implementation planning. And to this, we also suggest that the HRC is one such organization which the city, province, and national government. Insofar as the lessons to be learned, we have broken this down into three main concepts, which are the consideration of the people who this has affected undergo, people, the circumstances, and opportunities. Firstly, insofar as people are concerned, HRC submits that the overpopulation and over-reliance on the city for access to adequate housing and the provision of basic services requires some very comprehensive and practical solutions to this problem. The circumstances being the deteriorating condition of the city, the huge numbers facing total homelessness, and the projected future migration into the city requires its attention. The city has, for over a decade, understood the issue of migration, and I don't suppose we are any better 10 years ago, or rather that the city has made any plans and any sustainable plans for migration into the city, and we submit that this is an issue or a topic that requires their serious and immediate attention. Where opportunity is concerned, we submit that the reconsideration, we submit that there ought to be a reconsideration of the implementation of the housing policy, and with particular emphasis on the considerations on the shortcomings of the city's TEA programs and why this is not a solution that ought to be adopted by the city, and a recommendation that ought not to be made strictly by this commission. Second, if we were to consider the parallels between how far we have come from the position adopted in Blue Moonlight and Grootboom to where we are now, and if one is to have regard to what exactly it is that has been learnt since that time, it would appear that we are still in no better a position than we were in Grootboom insofar as the housing crisis is concerned and the implementation of the city's social housing program. And we, once again, on a repetitive note, emphasize the necessity of the immediate intervention which is required from province and specifically the national government in assisting the city with the crisis in the inner city. I then turn to make very brief submissions on the overview of the prima facie findings of, on the state of the buildings which were inspected. First, we wish to highlight and note the absence of structural engineers during the inspection in loco, whose expertise we submit would have greatly benefited the work of the Commission. I do appreciate, I was informed by my learned colleague, Mrs. Sitole, that this was a question which had initially been raised as to the presence of structural engineers. I'm just not aware of what the final conclusion was, but we do feel, or rather we do submit, that this was a missed opportunity to have engaged structural engineers who could have assisted and whose work and expertise could have greatly assisted the work of the Commission.
Yes, Ms. Sikati, how long does it take for a structural engineer to assess the building and give its report?
That
in
is
your professional view.
In my professional view?
Yes, having regard to the fact that this is a time-bound commission.
I take Madam Chair's point, and I certainly would be speaking outside of my own expertise if I was to give
but
an exact
timeline.
submission
That
yes,
this is a missed opportunity.
That is correct. So, Madam Chair, insofar as the missed opportunity submission is made, we suggest that if the Commission had had the expertise of those structural engineers, I'm not too sure how their processes work, but this could have given, insofar as the final recommendations that Madam Chair, as well as the Madam Commissioner would be making, would have given a greater insight into assisting the city on the plans in which it can implement on what is the solution for those buildings.
Yes,
for example,
but make me comprehend your submission that we have missed this opportunity. And my simple question is, how long does it take for a structural engineer to assess and come up with his or her report?
That is not I cannot give you a definite answer in that regard because I must concede, Madam Chair, I don't know how long exactly. But the submission, if I may, that we can make is that in the event that this Commission should make findings that some of these buildings are uninhabitable and require urgent evacuations, and if that is not the case for all of the buildings, we submit that a structural engineer, in the presence of a structural engineer, could have perhaps afforded insight as to whether or not there was a possibility for in situ renovations to take place while there is occupation of residents or occupiers in the building. And so the submission is made really around that. Finally, we suggest that the prima facie state of the buildings inform the Commission that the buildings require an overhaul of their management approach and policy, and where the buildings are owned by the city, managed by the JPC, the Johannesburg Property Company, some questions ought to be raised and answered as to the reasons behind the monumental failures on the part of the city and the JPC. In conclusion, the HRC's anticipated recommendations at the conclusion of Part 2 requires thinking which isn't confined to the orthodoxy of our times, but does not regress from the gains on the right to housing and access to basic services achieved through the jurisprudence over the years. In line with international law, all persons should possess a degree of security of tenure, which guarantees legal protection against forced eviction, harassment, and other threats. Despite these guarantees, the manner in which the evictions are conducted still results in large-scale rights violations. The HRC acknowledges that the law recognizes and protects the rights of both property owners and those who unlawfully occupy their properties. It is clear to the HRC that the Constitution and the jurisprudence of the Constitutional Court requires that a certain degree of empathy be exercised when eviction processes are undertaken, especially when such processes lead to homelessness of affected individuals and communities, and may I just add there as well, the rights and protections of children. The HRC will therefore recommend that all parties involved in the eviction processes / evacuations, including the courts, the local and provincial governments, and private property owners, amongst others, should undertake to avoid compelling the execution of these orders if these would lead to homelessness. In instances where the evacuations are required for the implementation of developmental projects, the city or other government stakeholders involved in the processes ought to ensure that evictions are an option of last resort and are conducted with the full consent or engagement of affected communities following meaningful engagement. In instances where consent cannot be obtained from the affected communities despite consultations, then a court order must be obtained prior to their eviction or evacuation. The provincial government, the city, and other parties involved must be aware of the fact that the evictions and evacuations are executed on the basis that emergency housing represents the first step towards a permanent housing solution, and must therefore plan to provide people with emergency housing and over time realization of a more permanent housing solution. In this regard, time-bound plans, we suggest, ought to be recommended and directed by the Commission and developed by the municipalities in consultation with the affected communities and must be made publicly available. We also submit that the city must conduct evictions, evacuations in a transparent manner, ensuring that the evictees are made aware of all the relevant details surrounding the evacuations. A further submission is that the city and the provincial government ought to ensure that in the event that temporary accommodation periods exceed 12 months, the norms and standards applicable to housing developments are applied to temporary accommodation units. All parties involved in the eviction process, including but not limited to the municipalities, the sheriffs, the private security companies, must ensure that they are evicted in accordance with the requirements of articulated law, giving due regard to the time of day and weather and due respect given to the dignity, the right of access to information and respect of all property of all persons affected. We appreciate, Madam Chair and Madam Commissioner, that the city is required to take reasonable steps in the protection of to protect its property against unlawful occupation and dilapidation of buildings in the event of occupation, whether legal or illegal, and in order to prevent the risk to health and safety of occupants and to guard against the necessity of conducting forced evictions when land is due to be developed. Finally, I wish to refer to some summarized points from President Cyril Ramaphosa's 2024 SONA debate speech, wherein the President expressed the following remarks on the Usindiso building fire. We've got to get to the bottom of what caused the fire. It's a wake-up call for us to begin to address the situation of housing in the inner city, that a building like this, once the lease had expired, was then hijacked, and we need to get on top of this and find effective ways of dealing with the problems of accommodation and housing and services in the inner city. We are not standing here to shift blame. and to pass blame on anyone. And if anything, we are all responsible for the calamity that has occurred, and we need to take it in our stride and say, yes, this should never have happened. Yes, we should be learning a lesson, and sometimes these are very difficult lessons that have been sparked by the loss of life. But nonetheless, this is a lesson, and yes, I repeat, a wake-up call, because we don't want to see a repeat of what has happened here. So therefore, we need to look at the regulations, the laws, and everything. These conclude our submissions. Once again, on behalf of the HRC, we appreciate the Commission's indulgence in granting us our participation in these proceedings.
Thank you, Ms. Sikati, for your opening submissions. Mr. Seminya.
We now can have Ms. Brenda Madumisa to
Yes.
deliver.
Ms. Matumisa.
Good morning, Madam Chair and Madam Commissioner. Thank you for affording us the opportunity as the former Gauteng Rental Housing Tribunal. And as I start with my opening statement, you will appreciate why we thought prudent to come before the Commission. Gauteng cities have ceased to be small, familiar places and become impersonal, heavily populated metropolis with new unfamiliar neighborhoods. New forms of organizations have emerged, thus provision of basic infrastructure as roads, water supply, sewage systems and electricity, and even the administration of justice and maintenance of law and order have, to varying degrees, ceased to be the exclusive responsibility of the state. People have gradually grown used to living outside the law. Theft, illegal seizure have become everyday occurrences and do not greatly disturb people's consciousness. Infiltration of violence and criminality into everyday life has been accompanied by increasing poverty and deprivation. Certain new attitudes towards the state have emerged. Citizens have resigned themselves to the fact that they must corrupt public officials if they want their needs to be satisfied. As former members of the Gauteng Housing Tribunal, our interest in participating in the work of the Commission was firstly to share insights on the rental patterns in Gauteng, and secondly, the work of tribunal as set out in the Rental Housing Act, and finally, to amplify the work of the tribunal and address the key challenges of enforcement, fragmentation, and lack of coordination by different government actors in the provision of housing and the legal instruments available to advance the state of law. On July 31st, 2023, the Rent Control Act ceased to exist, and the landlord, landlady were at liberty to increase rentals without restrictions and were no longer required to apply to a statutory body at the time the rent board for an increase. This was a huge relief to landladies, landlords, but created a crisis for the lives of pensioners and poor tenants. The Rental Housing Act of 43 of 2007 was introduced to stabilize the rental market in South Africa. It is intended to protect the vulnerable, as the preamble clearly embraced the fundamental rights entrenched in the Constitution, specifically sections 25 and 26. It seeks to inter alia protect parties from unfair practices and exploitation. Since its establishment in July 2001, the Gauteng Rental Housing Tribunal has adjudicated on simple to complex disputes between landlady, landlord, and tenant. During our tenure as the tribunal members from 2016 to 2022, we witnessed cases of exploitation, refusal to pay for services, lack of maintenance, lockouts, electricity and water cutoffs, tampering with municipal infrastructure, buildings abandoned due to non-payment of rent, hijack of these abandoned buildings, historical municipality debt owed by owners of these buildings in predominantly these areas, Yeoville, Hillbrow, Berea, Randburg, Rosettenville, JP, Mayfair, and the Johannesburg CBD. And now, Madam Chair, address specific issues that pertains to the work that we're doing. And non-payment of rent and services was a big one. And if you look at the statistics and the report of the tribunal that gets submitted to the Portfolio Committee on Human Settlement in the Gauteng legislature, you will see how we segregate the work and the concentration of non-payment of rent and non-payment of services being the largest part of the work of the tribunal. Amongst all the flats housing people in the above areas that were mentioned earlier, we can safely say, I mean, these buildings have at least 50 years being in existence. And when migration was not as chronic as it is today. Most of these flats were sectional titled, and over the years, the ownership has taken different forms, from being bought by individuals, cooperatives, private companies, and social housing institutions. The change of ownership of these properties and individual flats have been a contentious issue for most tenants found in these buildings. As former Gauteng rental housing tribunal members were at times confronted with fraudulent title deeds, and or when an owner takes over the building and starts billing for rental, the tenants will refuse to pay on the basis that the new owner is not the legitimate owner of the building. However, the building continued to provide the municipal services, namely water, sanitation, electricity, being consumed by tenants. These services were and are also not being paid for, but the owner is raking a huge debt to the municipality that is also not being serviced. This in turn has led to owners abandoning their buildings or, in certain instances, engaging the service of private individuals as rent collectors to enforce payment of rent and utilities. And I'm sure, Madam Chairperson, you know, in the work that you have done thus far, you would see, if you look at some of the so-called hijacked buildings, you will find that the municipal bill is massive. It's massive precisely because, one, you have had owners not be able to collect rent because the tenants were questioning the ownership of that building. And it was a pattern that was pervasive in Johannesburg, in particular the inner city. All these buildings and properties have bulk electricity, water and water meter and non-sub-metering but individual meters, right? The owners, in responding to complaints by tenants on high charges of water and electricity, resorted to contracting the services of external meter reading companies. The move was still not accepted by tenants, as they held the firm view that the owner and the meter reading companies were profiteering from the provision of utilities. The owners have been inundated with demands to install prepaid facilities, but some of these buildings, because of their age and design, do not lend themselves to the solution. And we experience that on a regular basis when tenants come before the tribunal querying the payment of water and electricity and insisting on prepaid meter being installed, and the owners putting the position that it will be too expensive to do so because the buildings as they are designed don't lend themselves to that. So it was a contentious issue with the tenants, and they were not accepting of that argument. Overcrowding and subtenancy. So, you know, we talk of migration and that people needed to be closer to their workplaces, and then what then tends to happen in these areas, you have overcrowding, and the overcrowding then leads to subtenancy. So you have an individual who would become a tenant, but then will sublet to others, and they sublet not just to one, it will be multiple tenant. That individual is the one that the rent is paid to, and in turn, that individual must pay to the owner, and sometimes that rent is not paid to the intended owner. And as I read out, Madam Chair, that most leaseholders or tenants in most of these buildings don't live in the said apartments rented. Instead, they sublet a one-bedroom apartment to as many families as possible, collect the rent and not pay over the rent to the landlady or the landlord. The landlord or the landlady response to subtenancy, which leads to overcrowding, is either a lockout, and that's what they were doing. or water and electricity cut-off, because they just felt that they are overwhelmed by the sheer number of people found in their buildings, and they are not receiving the payments, right? And they will resort to the tribunal for the tribunal to engage. So as I'm saying, that leads to overcrowding. Either there's a lockout or water electricity cut-off, which were unlawful and are still unlawful in terms of the Rental Housing Act and regulations. And in certain instances, the owners of the buildings will introduce a biometric system to recover rent, because that's how they then determine who lives on the property, who is a legitimate tenant in flat 2 or flat 5, so that they know the number of people who are living in that flat, and they create a billing method for water and electricity, and in especially water. You will find that with water, they count the number of people living in a particular flat, and they use that number to determine the amount of water that should be paid. Let me move on to maintenance, Madam Chair. It's a big one around maintenance of these buildings, and in particular the individual flats, right? Huge challenge in the rental stock markets with properties found in the aforesaid mentioned areas. Owners maintain that they cannot maintain the buildings or property due to non-payment of rent, while the tenants maintain that the unwillingness to pay rent is because of the lack of maintenance of the property. So you are not maintaining. The owner says, I'm not maintaining because I'm not receiving my rent. The tenants say, but we have been paying you all along, and you have not done what you were supposed to do, right? So we had to adjudicate these kinds of disputes, right? Our observation as the former tribunal members is that most tenants do not read the terms and conditions of their lease agreements, specifically the sections on internal and external repairs, maintenance responsibilities and obligations. Because if you are a tenant and you have signed a lease agreement, that lease agreement will provide for the responsibility of the landlady and that of the tenant. What is it that you as the tenant you are responsible for, and what is it I'm responsible for as the owner of the property? In most instances, that was not understood. And that's why we had a huge number of disputes around maintenance of these buildings. And one of the third issue, Madam Chair, is the acute and lack of understanding of how municipality functions and provides services. You would have tenants coming to the tribunal to query electricity bill, to query water bill, to query a waste bill, right? And when you then spend time in explaining that whole process, then you realize, and that's when they realize that the money is not going towards the owner of the property. It has to service the city. In their mind, all along, they thought that this money is being taken by the owner, and the owner is doing whatever he's doing with, and they are entitled to those services. And they don't want to hear anything else but that they have paid for these services, but they query the amount that must be paid, right? So in most of these buildings, as I said earlier, Madam Chair, is that if you don't have a proper metering system or a proper billing system in these flats, the owners have run the risk of having to fight with the tenants, because the tenants are saying, you claiming that I have consumed 500 rands worth of electricity, but I don't see how you determine that. But you claim that I've consumed water to that effect. And the tribunal, when we request an explanation, the explanation that will be given by the landladies or the landlords would be that they used a particular method. One of the methods that they use is to count the number of tenants found in the particular flat. If you are 5, then we are going to be 5 times 50 rands, for instance. And that's how, and in fact, even children, I mean, there were leases where you'll find that they have provision for even a child, that a child, if you've got a child under the age of 10, they pay 50 rand towards water and adults pay 100 rands. And then you calculate if you have got 4 adults in one flat, is 4 times 100 rands plus the 1 child or 2 children, 50 rands, and that's the method that they would use. So landlords found different ways of calculating usage of utilities, municipal utilities. And Madam Chair, in conclusion, and I'll sort of segue and pivot to what the Human Rights Commission's submission was around evictions, and share this with the Commission. In most instances, especially when you have been given notice to vacate. Remember, in a lease agreement, you have signed that you can vacate. If there is a breach of the lease agreement, or that your lease has come to an end, you must vacate. In most times, you had tenants believing that is the role of the state to find them alternative accommodation in a situation like that, where you have agreed that after 30 days, because the law gives you the right that I must give you notice, 30-day notice to vacate. And there was a confusion between voluntary vacating and eviction, and people believing that once I give you notice as a landlady or as a landlord, I'm evicting you and I'm saying that you must move now. And I have not read the provisions of that lease agreement that it actually gives you also, a tenant, the right to resile from this contract or even leave my property and give me notice within 30 days. And I think it's something that we really need to look into, because there is a perception, and it's becoming very pervasive for individuals who enter into rental agreements, believing that they cannot be, you can't give them notice to vacate. And that's why I want to draw this distinction. The eviction comes at a point where an owner of the building has now gotten to a stage where they're at their wit's end. They have done everything in terms of the law. They have given notice, they have given someone to remedy the breach, but still the individual is refusing to move out. And the individual's argument is that, find me an alternative accommodation. I'll only leave your property once you provide me with alternative accommodation. And I think it's important in the work that the Commission is doing to ensure that almost all of us who are part of this process, but broadly as the Commission in Gauteng, that issue is highlighted and is understood very well. Thank you, Madam Chair, for the indulgence.
Thank you, Ms. Madumisa, for your opening submission. Mr. Siminya?
Chair, yes. We also extend our thanks to the various parties. But, Chair, unfortunately, we have to make the observation that the opening statements tended to straddle the rules of opening statements and closing statements. For instance, regarding the inspections in loco, there was an appreciation by the evidence leaders that if we sought to take structural engineers to these inspections and had to abide by procurement processes by which the services can be rendered, there was never going to be an inspection in loco. But also there's an appreciation in those reports that says prima facie there are indications of a structural unsoundness in respect of certain buildings, and it is not unlikely that the final report may very well say, in the light of that prima facie evidence, the city urgently has to investigate urgent interventions of an informed expert opinion. So there mustn't be any reading of that to say that the commission was remiss. That the commission was remiss. But anyway, we will get to these points. We will have the benefit after evidence to do as the rules require. In opening statements, you make no submissions. You just tell us where you're going with your evidence. But in closing submissions, you do make submissions, and,
Yes.
and those are points of law.
I suppose you will get your time when an appropriate opportunity arises, Mr. Siminya.
Yes, yes, Chair. That would be the business for the day, at least in the formal hearings. We have a witness ready to come tomorrow morning, Chair. With your direction, this is the end of the day's work.
Is that Ms. Rivers?
This is Ms. Rivers.
Yes. These proceedings are adjourned until tomorrow morning at 10 o'clock.